us. So thank you everyone for attending the one-on-one conversation and bankruptcy and preference demand through the pandemic and beyond with Wanda Borges, Esquire, our expert, our industry expert today. So Wanda, we've heard so much about, we have 10 minutes to cram everything in, so we'll get right to it. We've heard so much about the bankruptcy law changes and retailers going bankrupt that we never expected. What is happening out there? What best practices can you share with our credit practitioners today so that they can keep their bottom line high, and also what to do or how to handle or avoid those dreadful notices that we get, the preference demands and bankruptcy notices?
Thank you, Donna, and it's my pleasure to be here today. Well, in a very short period of time, let me say this, the retailers, that's obvious. Over the years, brick and mortar stores have been getting less and less business as more people move online. When COVID-19 hit, no one was going shopping, everybody was at home, so the brick and mortar stores suffered drastically. When you see a company like JCPenney's that has been around forever, and they have 70,000 employees,
wow,
and they filed Chapter 11, you know, this is a new, different world that we're living in. Fortunately, some of the stores are coming out. What we are seeing is that there's a store called Tuesday Morning. They have just filed a 100-cent plan. JCPenney's has a plan in the works that is going to involve the landlords actually coming in and buying out some of the real estate to help JCPenney. So we're seeing a lot going on with these retailers. Some of them will survive, some of them are going to be gone. The bankruptcy courts have changed. I never dreamt that I would be on a Zoom court appearance. And talk about the JCPenney case, in the JCPenney case, there are sometimes in excess of 400 people on that bankruptcy court appearance. The judges have had to learn technology, perhaps some of them never wanted to, but every court appearance today in the bankruptcy court is either by teleconference, video conference, or some form of Zoom and combination of conferences. Even trials are being held remotely, or evidentiary hearings, as we have them in bankruptcy all the time, are all being held remotely, and contested matters are being held remotely. And it's very interesting because the active players are permitted to appear and be vocal, but those that just want to watch will actually appear on a listen-only mode. So a brand new world. What can our trade credit grantors do to protect themselves? You've got to be more diligent than ever to watch what's going on. Sometimes we've seen some of these retailers file that came out of the blue, no one expected it. But on the other hand, what you can be doing is watching your receivables, and I'm going to give you two different perspectives. One is when you start seeing slowed payments and slow down orders, well, you know something's happening if they don't need the product anymore. But the reverse is also true. When suddenly you're seeing an increase in orders, and you may get a large order that you didn't really expect in the past. I had a couple of clients on the Tuesday Morning case tell me they haven't bought anything from us in a long time, and suddenly we're being barraged with orders. We thought something was happening. And of course they did file. So that is certainly, those are the two things that in particular to watch for, the slowdown or the uptick.
Okay.
And that's what's going on in the bankruptcy court proceedings.
And how backlogged are you finding the courts are?
Well, you know, there's a big difference between what's happening in the bankruptcy courts and what's happening in the state courts. In the state courts, they pretty much shut down when the pandemic first hit in March. Many of the governors issued orders just saying, that's it, we're done, we're not having anything going on anymore. But what is happening now in the state courts throughout the country, I talk to my colleagues all the time, we're seeing that the courts are open, but we're not seeing judgments being entered. None of the courts seem to be liking to enter a default judgment. They're giving the defendants, the debtors, an opportunity to come forward, and they want you to notice them and make sure that there's no question that those debtors were served with papers in the first place. New York, we're seeing virtually no default judgments whatsoever. Now, interesting, with the COVID, a couple of things happened, both with respect to state litigation and with respect to bankruptcy. Many of our trade credit grantors know that the Small Business Reorganization Act went into effect in February of 2020. Well, gee, a month before COVID hit. So the minute COVID hit, the legislators actually increased the dollar amount that could be used by small business bankruptcies to qualify as a small business, to the point that it's now $7,500,000. Well, you may say, wow, that's not really a small business, but with all the businesses being hit, that's what they felt was logical now. That is due to expire in March of 2021. We'll see if it does or does not. At the same time, what we saw was with the Small Business Reorganization Act, there's a lot more leniency in getting a plan put forward in a small business. And when I say small business, think about this. Small businesses, yes, under $7,500,000, but a lot of your mom and pop companies that you're selling to, but courts are also accepting as small business Chapter 11s personal guarantors. So it's not just Chapter 11s, Chapter 13s, but it can also be individuals that guaranteed corporate commercial debt. And that's the trick. It has to be corporate commercial debt. 50% of least has to be commercial transactions. And they can file, at least 2 courts have been litigated and have found that those personal guarantors can in fact file small business Chapter 11s in order to get forward.
And that's something new in the courts, something new with the new legislation.
With the new legislation and the way the courts are interpreting it, those 2 court decisions both came down in July and August of this year, saying, no, these personal guarantors can be allowed to file as Chapter 11s.
Wow.
Lastly, and I think I'm jumping the gun on you, Donna, but I know you're going to ask a question about how can they secure their receivables. And I'll say this: documentation, documentation, documentation. Make sure everything is as perfect as it possibly can be. One of the chagrins I've had over the years is that trade credit grantors tend to have sloppy documentation. Make sure you know who you're dealing with, make sure you know which corporate entity you're dealing with, but also go out and get those personal guarantees, get cross-corporate guarantees, and I'm just going to mention it because I know Jerry is waiting to talk about it. Get your Article 9 protections, your security interests, your purchase money security interests, and most importantly, and here is a place where creditors got burned badly, consignments. Make sure your consignments are done properly. In the Sports Authority case, a tremendous amount of trade creditors got burned badly because their consignments were not done properly. So documentation is the key. Donna, I'm going to leave it to you for a moment. Do we have, I don't know, I'm not watching the clock. I know you are. So I do
have someone watching. So just, you gave some information, but if we could have one takeaway for our listeners today, what would you tell them? Just give it to us in one little liner, because you seen popped up, and that's my.
I'm the referee. I'm the referee. But no, that's okay. I definitely want to hear this.
Go ahead.
Well, I think my one liner, besides being documentation, 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 is diligence. Creditors have to be more diligent than ever. They cannot just look the other way and let their accounts slide. They have to be on top of those accounts, and expect that some of these bankruptcies are going to come out. So don't be afraid to deal with them post-petition. I've had several success stories with clients dealing with debtors in possession, getting paid sometimes they're 503b9 and more, getting treated as essential vendors. So don't fear doing business. Be diligent, be extremely diligent, make sure your documentation is in order, and don't fear going forward with debtors in possession.
Thank you, Wanda. Just always a wealth of information. I know we can talk another hour on this, so I hope we can do this again very, very soon.
I look forward to it.